I have been working on the table of contents to one of the binders that I'm working on for my case. There is going to be one for the original judgment and sentence. This is for the new offense, and then I'm going to have one prepared for the aftermath of everything that has happened as a result of binder 1 and binder 2. But here's the table of contents for binder 2. Even though I have an email indicating that I reached out to the Vancouver Police Department on the 25th, after receiving the public records, the police report indicated that it was the 26th. So I just left it as they have it, and they assigned me a case number and a reference number for tracking purposes. On September 24th, 2019, I petitioned for an order of protection. Under this case number, I had a statement, I had a photo, and on all 11 pages, there's no judge, commissioner, or deputy signature, and I was just told to return the next day to appear before Liebman. The next day, September 25th, 2019, I was given a denial order for domestic violence. Same case number. The court finds that the petition has failed to demonstrate that there is sufficient basis to enter a temporary order without notice to the opposing party. Court orders that the request for a temporary order is denied, and the clerk is directed to set a hearing on the petition. I was given another hearing date and time for October 8th at 8:30. A memorandum in response to petition for order of protection that was submitted on the 24th was submitted by Bennett almost a month later. This order, September 25th order, was signed off by Liebman. So October 8th, 2019 arrives, and I go before the judge for a reissuance of a temporary order for protection and notice of hearing on this case number. The temporary order for protection issued on, it just said NA with no explanation, but I was given another date and time for October 29th, and this was signed off by Gregerson. In the meantime, October 11th, I reached out to DOC by text, and October 15th by email to the Community Corrections Officer, Courtney Bogart. There's where she works and phone number. October 18th, I went to the Camas Police Department and made a report because I did not hear anything back from the Vancouver Police Department, and Courtney was not returning any of the text or email that I had sent. October 19th, I had filed the proof of personal service that was served to Chris. So I was following the order of Liebman. October 23rd, Courtney pulled Chris for questioning, and Chris did a specific issued polygraph. Mr. Anstead submitted to a specific issue polygraph regarding the allegations that I brought forward to the judges. And Mr. Anstead's significant psychological reactions indicate that he was, in fact, being untruthful. Courtney Bogart further says that his current actions present offense cycle behavior, and it is in her professional opinion, if Mr. Anstead has not already reoffended, he is on track to. Courtney Bogart's recommendations was 30-day confinement, the court review the parenting plan, and to modify the judgment and sentence to reflect his requirements. October 23rd, 2019, a declaration of Christopher Anstead was submitted. October 24th, 2019, the court notice of violation was e-filed by Community Corrections Officer Courtney Bogart and her supervisor, Phil Coleman. October 24th, so just keep in mind all these dates. Same day, order for arrest and detention, and it indicates that the offender location or the jail is Clallam County Violator Facility. This was approved by Supervisor Phil Coleman. His signature was the only one that I found on there. October 24th, 2019, a memorandum of disposition for the criminal case was submitted. For the crime, the defendant is hereby remanded to custody. It says hold without bail. The defendant is hereby ordered to return to court November 6th. Remember that day. And there's a little note under other to admit or deny the violation. This was signed off by Daniel Stink. October 24th was a busy day, and a motion and declaration for order revoking SOSA pursuant to RCW 9.94A.670, 4 and 5 comes now the state of Washington and Kamara Banfield, the prosecuting attorney. The only signature that I saw on this one was James B. Smith, WSBA 35537. James B. Smith is the deputy prosecuting attorney for Clark County, prosecuting attorney, and also for the Children's Justice Center in Washington, Vancouver, Washington. That's his information. On October 25th, 2019, I submit a declaration, and I also have in here the violation that had just happened. October 29th comes, and I go before the judge again for the reissuance of a temporary order for protection and notice of hearing. So they have the same case number. And the temporary order for protection issued on, they write in A again. It is ordered that the clerk of the court shall forward a copy of this order on or before the next judicial day to the Clark County Sheriff's Office. I found that to be interesting. Respondent appeared is what was checked off via Roger Bennett. So Chris did not appear, his attorney did, and was informed of the order by court. Further service is not required, which I found that to be frustrating because they had told me to do proof of service, and I went out of my way and made that happen, and then that was not even recognized because it says and was informed of the order by the court. Further service is not required. I was given another hearing date and time for November 5th of 2019. And this was signed by Commissioner Scheinberg. On October 29th, 2019, a citation was filed with the court for the criminal case to Christopher Ryan Anstead and Roger A. Bennett, indicating that they are notified to appear in the Superior Court of the State of Washington before the Honorable Susan L. Clark, Judge of the Superior Court, in the assigned courtroom, Wednesday, October 30th. Hearing regarding PV review. The only signature on this is James B. Smith, Clark County Prosecuting Attorney, Child Abuse Intervention Center, is all of his information when that was submitted. October 30th, 2019, there was an order modifying the judgment and sentence and community custody conditions. So this was filed under the criminal case presented by the Child Abuse Intervention Center, Clark County Prosecuting Attorney James B. Smith. Agreed by Christopher Ansted's attorney Roger Bennett. Signed by Superior Court Judge, it says, Amy Swiggin. Another thing was submitted October 30th. This was mailed to me October 30th. A letterhead from Prosecuting Attorney Anthony Golick, Chief Deputy Scott Jackson, Chief Criminal Deputy Kamara Banfield, Chief Civil Deputy Emily Sheldrick, and Administrator Sherry Jensen for Clark County, Washington. They just wanted to let me know that they received, and this is regarding the report of abuse, the suspect and victim, and went over the Vancouver Police Department report. And it says, I have reviewed the police reports concerning the reported abuse. Based upon the reports, it is our decision that there is insufficient evidence to pursue successful prosecution. Accordingly, the state will decline pursuing criminal prosecution for this reason. And the only signature that was there was James B. Smith. And this is all of his information on that letterhead. I came across, when I was looking up, the prosecuting attorney, Anthony Golick, and I came across this message from him. It says, too often victims of crime take a back seat to criminals when it comes to having rights within the criminal justice system. Here in Clark County, the prosecuting attorney's victim assistance unit is doing everything possible to see to it that the victims of crime are treated with the respect, dignity, and courtesy that they so rightfully deserve. Providing the service that we do to crime victims helps to enhance the justice in the criminal justice system. We strive to provide justice for the victim as well as the criminal. It is the goal of the Clark County Prosecuting Attorney's Victim Assistance Unit to balance the scales of justice. Victims have the right to information, respect, dignity, and freedom from harassment and inconvenience. It is our desire to see that the criminal justice system does not cause a second injury to the victim. Signed by Tony Golick. So that's just a little side note. I get an email same day as the order to modify the judgment. Same day, the letterhead was mailed out to me. Email from the Vancouver Public Records Center thanking me for submitting my request for the following public reports, and that they will be contacting me within 5 business days with an update as to when the responsive records will be available. So, yeah, that was a little bit frustrating. So, same day again, October 30th, 2019, now there's an order modifying the sentence. This matter came before the court with the defendant present, represented by his or her undersigned deputy prosecuting attorney. So let me read that again. This matter came before the court with the defendant present, represented by his or her undersigned deputy prosecuting attorney. It was disclosed at that day and time when this order for modifying the sentence was taking place, that the defendant is in violation of the judgment and sentence as alleged in violations. As punishment for violating the terms of the sentence on the felony counts, the defendant shall serve a whopping 7 days. In the other comments, it says see companion order. This was approved as to form James B. Smith and Roger Bennett, signed by Judge of the Superior Court, Amy Swiggin. This was on a form through the Clark County Prosecuting Attorney Children's Justice Center. Another October 30th, 2019 memorandum of disposition was entered under the crimes here, and the defendant has been sentenced to confinement. The defendant shall report to the Department of Corrections within 24 hours of this order, and it says release from custody. There's a remark under other that I found to be interesting. Defendant shall also be released on any DOC holds under the criminal case. And the judge of the Superior Court who signed off on that was Amy Swiggin. And the only other two signatures that were there were James B. Smith and Roger Bennett. Now, November 5th comes along, and I again get denied for protection. Case number, it's a full order. A preponderance of the evidence has not established that there is domestic violence. There is a remark under the other, which Scheinberg indicates the need to modify the parenting plan, just as Courtney Bogart had mentioned. The request for full order is denied and the petition is dismissed. November 6th, I found a Journal of Criminal Minute entry. Case number is the criminal. Reporter, there's a video. Defendant appeared, no, strike per PA, and the judge who signed off on this is Valjacek. Remember, he was supposed to show up to admit or deny the violation, and it says that he did not. November 6th, an email was sent from the city of Vancouver, Washington to me from the Vancouver Public Records, and the attached records that they let me see was 6 pages, but it also says that the Vancouver Police Department has made redactions to the documents where information is exempt from disclosure. November 8th, I had tried again, but this time with an attorney for an immediate restraining order and was denied. It says that Lewis was the judge, but there's no signature. And it was prepared by Lindsay Stallings, the attorney that I had representing me at that time. November 8th, 2019, there's a response that was submitted to motion immediate restraining order that I had filed for the family parenting plan side. Amanda versus Christopher. On this response, it says that the respondent is entitled to be heard in an attempted ex parte proceeding. 2, there is no imminent danger to anyone based upon petitioner's accusation, as has been determined by 3 judicial officers already. And Christopher submitted this, but Bennett signs it. Bennett indicates that I was denied the first time which is really the second time, by Lehman. And then he, for some reason, does not record October 8th or October 29th. November 5th with Scheinberg. October 30th, Judge Clark made one minor technical change in the conditions. I read that it was Amy Swiggin, so I'm a little bit confused about that. Petitioner's allegation of a failed polygraph is unsupported and misleading. No, not really. It's pretty black and white. Petitioner is not entitled to credibility in her claim of imminent danger to her children, and there is no basis for a temporary restraining order because respondent has no contact with his children and also asked for relief. There's no judge signature on this. I was getting threatened at that point already of if I do not follow through with the parenting plan, I would be held in contempt, when I was trying to indicate to everybody that there is restrictions and requirements in place that needs to be on the parenting plan. I was exhausted at this point, and December 31st, 2019, met with Roger and Christopher to stipulate an amended and ordered modifying the parenting plan. The parties hereto have met and conferred in order to clarify, modify, and amend the existing parenting plan, which was entered by agreement on August 4th, 2017. So I was assuming that a new chaperone would be in place for me to feel comfortable that my children were safe. And this is where they brought in June Taylor. And Christopher Ann said, we'll have makeup time for missed visits with his children, even though he missed it because of all of the modifying things that were happening in October. And it says, commencing upon the weekend following issuance of a certificate or letter by Dr. Tom Brewer approving June Taylor as a trained chaperone for their children. That was signed by Gregerson. I have the 8 weekends, June Taylor's text messages, and Christopher Ansted's text messages showing that I complied with the makeup time, even though I later found out that June Taylor was never even approved by DOC, which is part of Christopher's original judgment and sentence to be able to have supervised contact in the first place. But I followed through, and here's proof. So this is the second binder.